and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Thanks, Tex. That's what we need at 5 minutes past 10. Yes, your talkback lawyer is back with you. David Whiting, Melbourne solicitor, who's been doing this job for longer than any of us can remember and who says he's coming round to the new theme. Good morning, David.
Good morning.
You did say that, didn't you?
I did. I said it last week. I'm not sure now, but I did say it last week.
I'm just going to put those words into your mouth.
I understood.
I put it to you,
It's
David
a good
Whiting.
journalist
I
does
put it
that,
to you.
yes.
I put it to you
Yes.
that you did, to a certain degree, enjoy that theme.
To a certain degree, absolutely. I actually went and listened to the song a couple of weeks ago
did you?
and thought, yeah, I like it. It's just, I don't know, it doesn't flow particularly well. But, that's Tex. Never mind.
Honestly.
It's your program. You do it whatever way you like.
Could you? But I think the message in it is good. Get yourself a suit and tie.
You need a lawyer, son.
And
get a good one.
And get your hair cut way up high. You know, you long-haired lout. The judge ain't going to like you.
Well, I must say, the advice I give to clients is dress like you normally do. Dress well, but, don't go out and buy a suit to be the defendant, which is what you would have done 20 years ago.
Oh.
It's now try and dress properly. So you might change your tracky dacks for trousers but apart from that, no.
I disagree. I like to see people in a tie and in a nice outfit.
I'll remember next week,
I think,
okay?
Yeah.
Okay.
Yes,
I do have several
Yes, young
ties.
man, you with your open neck shirt
Yes,
there.
I have. Yes, it's still a suit, but the tie, and I act for a tie manufacturer, but the ties just aren't like they used to be.
No homework today, but you've got a couple of interesting items to share with us. One I was discussing earlier, last week actually, in relation to the Right to Know campaign, the number of suppression orders in this state. Oh, my goodness. Crazy.
Yes, and then, of course, there's the suppression order that says I can't tell you about the suppression order I've just made, the super suppression order.
Yeah.
There was lots of press a few years ago about one in the UK, but there have been a couple here in Victoria. And suppression order, there's a suppression order when the reporting on the case says that the name of the defendant cannot be disclosed for legal reasons, or the name of the witness.
But the comparison with a state like New South Wales is not good for Victoria. 1,204 suppression orders issued by the courts here since 2017, compared to 490 in New South Wales. Now, I got a bit of pushback and telling me that, this was in cases of sexual assault, but I know that's not true. A lot of the times it's because barristers are very good at arguing that their clients will be embarrassed if it gets out.
I think that's the major reason that they're granted, because we've got a community that doesn't actually distinguish between an accusation and a conviction. But when I started in the law, South Australia was the place to get a suppression order, not Victoria. Now that's 30 a week of suppression orders. That's just way too many. The other problems with suppression orders is they rarely have an expiry date, so you've got to go to court and deal with the suppression order, make it to go away, and so they're the major problems.
You've also got a justice delayed story for us.
I've got two.
Two.
One is some of us will remember an investment company in New South Wales called Babcock and Brown.
I do.
And Babcock and Brown went under 10 years ago, and there were three creditors who made a claim against the liquidator, and the liquidator denied the claim, and you have the right to appeal to the federal court. In that particular case, the federal court was heard in a fairly short 3-day hearing in 2016. October 2016.
Right.
October 2019 was the delivery of the judgment.
3 years.
Yes. All right. Now, it would appear that the judge was unwell.
Okay.
But
Then I'll stop chuckling.
And there were 12... I know some of it must be incredible frustration for a party, but there were 12 self-imposed deadlines, all of which were missed, and it's worthy to note that the claimants have now decided that they will appeal His Honour's judgment.
Oh, no.
So
Another 3
presumably,
years.
though, the Court of Appeal will be a bit shorter.
If the judge was so unwell that he or she could not actually decide this matter, then isn't there a provision for it to be transferred to somebody else who's well? And frankly, to let this person go and get well, just to look after their health.
There's two approaches. One is you actually take out life insurance on the judge for the cost of rerunning the trial.
Who's the you?
the parties, so the plaintiff and the defendant would say to the court, look, we're really concerned about the health of the judge. Can we take out some, it's cost us $1 million to run this trial. Can we get some life insurance on the judge, please? It doesn't happen often, but it does happen.
Crazy, okay.
There's an issue about what you would do. One of the issues in most trials is the demeanour of the evidence. It's the demeanour of the witnesses. So you can listen to the audio, you can read the transcripts, you can read the documents. So you could have, if the parties agreed, then otherwise it's a rehearing. So if the parties agree, and I've also heard of cases where the judgment is finished but the judge doesn't deliver, the judge dies before handing down judgment. In that case, the decisions are reviewed and delivered. Let's
get some advice for our wonderful listeners today. 11 minutes past 10 on ABC Radio Melbourne.
Deal with one very quickly. Yeah. And it's an issue about delays in the family court.
Yes.
The court will not tell you which are the slowest jurisdictions. In April this year, the Chief Justice of the Family Court said that in some court locations, more than half of cases were more than a year old and 25% were more than 3 years old. And when asked by the media, could you tell us which are the courts that are the slowest or give us some statistics? Answer is at that stage they've clamped down. Not enough judges.
Again, you're right to know.
Yep.
You can't know, and you can't know about the slowness of the process as well. Our number, of course, is 1300 222 774. If you'd like to book a slot, there's not many left, I have to say, to chat to David Whiting this morning. First up is Robert in Geelong. Let's see if I can get you on the line. Robert, good morning. Hello.
Hello, Virginia. Hello, David. How are you?
Very well.
Look, just off the track a little bit. I really like the Tex Perkins song, but not as the theme.
Well, I'll get to decide that, young man.
That's all right. You might have to have a little quiet vote with everyone that brings it up.
No. You're talking about right to know again. That's not going to work.
This is not a democracy, let me tell you.
Look, maybe a simple question, David. I just want to know what my obligations are. I've been with a new energy provider for 6 months.
Yes.
They have my exact name, my exact email, my exact address, my exact phone number, my exact pension card.
Yes.
I've rang them 4 times to tell them they're getting it wrong, but they haven't sent me a bill, and they're sending it, I think, in the old person's name.
Yes.
That I return it back to them with return to sender, not at this address. You need to check. They have moved to an address somewhere near here, I know, but that's all I can tell you. I just wonder what my obligations are when I ring them up. I rang them for call centre 4 times, and I think when they pass it over to the next person to correct in the computer, it gets lost. But when I do an email to them and ask them what's going on, it says, everything's okay, you owe us $0.
Yes.
And we're still preparing the next account for you.
Robert, there is are you interested in the energy company making money, or are you not getting frightened?
Well, if it goes on for more than 6 months, which is at now, and then goes to a year,
yes,
as I slowly...
Their clawback is only 6 months. They can give you an amended account, but they can't go back forever.
Okay, because I'm just slowly hitting my head against the wall and it's starting to hurt.
Yes, you might talk to the Essential Services Ombudsman.
That's what I need to know.
And you would go to them and say, I've got a real problem. I'm happy that I'm not happy that I owe them money, but I acknowledge that I do. They just want their billing system's not working.
Yeah, okay.
Good luck.
Thank you very much.
Thanks, and thanks for the advice about the theme too, Robert. Kate in Brunswick, good morning.
Hi, Virginia and David. I just have a question. I'm the chair of an owners corporation committee, and we recently voted to terminate the contract with our manager because they're hopeless.
Yes.
And we have a new manager chosen. We have a ballot and so on. We sent a notice of termination to the current or the old manager, and they're refusing to hand over the records to the new manager.
Because?
Because they're in denial about the change of manager.
Kate, I once had to have a look at this a few months ago for an owners corporation in eastern suburbs. And there are very, very precise rules for the taking of the ballots. And if you don't take the rules, or if you don't follow the rules precisely, it is as if there is no ballot. This was a small owners corporation of about 6 people, and phone calls had been made and emails had been sent and received. But and while it was the unanimous view of the unit holders that the OC manager should be terminated. The process that had been followed by the members of the Owners Corporation didn't comply with the Act, so the Owners Corporation was able to say, it's as if you haven't done it, so I'm going to ignore you.
Right. That's interesting.
All right, so look at the Act, Owners Corporation Act. You can get it from legislation.vic.gov.au.
Yep, got it.
Follow the rules, give copies of the outcome of you've got to give a copy of the ballot and supporting material to the Owners Corporation manager after you've completed the ballot, but follow the rules. If you've followed the rules and they won't hand over, then you go to VCAT.
Excellent.
All right, if you haven't followed the rules, start again.
Okay, no worries. Thank you so much, David. Thanks.
Good luck, Kate. Marul, in Tarneit is with us. Good morning.
Good morning. How are you?
Well, thank you. Go ahead. What's your issue that you'd like David to help you solve?
Yeah, David, my son last week fell down in a school in a morning recess around 10 o'clock in the morning, and school didn't inform as a parent, and we didn't know until he arrived home, and it's an independent school. So what should I do the next?
Because it's an independent school, the state system won't help you, but they do have an obligation to notify you. Have they given you a reason why they didn't?
No, I sent few emails to principal, and they say we are under investigation, but no one called me or no one sent any report or something. So far, it's been 1 week.
I would probably agitate a little bit more. There is an organisation called the Association of Independent Schools in West Melbourne. If they're a member of that, you might express your concerns via them.
What is the school obliged to do, David?
Well, in the normal, every school has their own policies about how they report or relate to parents.
Yes.
I don't know in this particular case what report was provided by the student to the school. Sometimes there are none.
They asked me all the details, what your son told you, what's happening.
Well, I understand that, but you see, the question is not what I accept what your son told you.
Yep.
But did your son report the falling?
Yes. He went to the healthcare centre and they just gave him ice pack. Yes. And they didn't even call me, and he had actual fracture in ankle.
Ouch.
So he went around for the rest of the school day with a fractured ankle, did he?
Yes.
And the school didn't inform you of the fractured ankle?
Yep, that's correct.
If you don't get the response you want from the principal, I'd probably write a letter to the chair of the school board. That would appear to me to be just a totally unacceptable outcome.
Marul, I'm not wanting to put this thought in your mind, but I'm just asking, are you thinking here about taking some sort of legal action against the school, are you?
Yes, because he suffered like a 6 hour, and we've been told by doctor if we took him to the treatment earlier, it's a lot better than worst.
Yes.
So,
my problem is actually proving what I see an issue in relation to loss. There would need to be a loss that the student suffered as a result of the 6 or 7 hour delay.
Yep.
That to me is, so I would be trying to resolve it at the school level. You might like to go back to the doctor and say, is there any long-term or permanent damage as a consequence of the delay? And if there isn't, then we have a system that basically doesn't help you. You're supposed to wear the first 5% of loss yourself.
Okay.
Yep.
Good luck, Marul, and I hope your boy gets better. Is he okay now? Is he at least out of pain?
Yep, thanks for your help. Thank you.
Okay, thanks so much. Louise in Geelong, good morning.
Oh, good morning. Just a question on power of attorney. If someone has power of attorney over someone who's incapacitated, medical and financial, do they have the power to appoint another power of attorney in case something happens to them?
Are we talking about the person who we call the donor, that is the person who gives the power, or the attorney, the person who takes the power?
The person who takes the power.
No, you can't delegate. If I had your power of attorney, I could engage someone to do a task for you, but that's not delegating my power under the power of attorney.
Right.
But if I was going overseas for a month, I couldn't appoint someone to take the role in my place. But you can. The donor can come along and say, I'm appointing David, but if David is not available, then I'm appointing somebody else.
The donor
The donor
Alzheimer's.
has the power to do that, yes.
You can organise or declare like a trickle chain, a sort of a tree, if you like, of people who have that power and can.
There's currently 2 people in the family, and
Yes.
I have no problem with that at all.
Yes.
But they're both travelling together next year, and it just came out of the blue to me. What if they're in a
So the
got
answer
forbid
is
a car crash or
yeah,
something?
but it's the donor who has to do it, not the attorney. So,
But the donor has Alzheimer's.
well, then it can't happen then.
Oh, okay.
So but remember, it's the attorney can engage people to perform the task. Does that make sense? So let's assume it's your mum and your brother and sister are appointed as the joint and several attorneys,
Yeah.
and they're appointed the decision makers under a medical treatment decision maker. If they're both travelling overseas and your mum needs to go to hospital and decisions need to be made and she can't make them,
Yes.
then it would be the next available next of kin.
Oh, okay.
All right?
Yep. Okay. Thank you
Okay.
for that.
Thank you.
Good luck. Good to talk
Bye.
to you. Thanks for calling in this morning. Our number, if you'd like to join David Whiting, is 1300 222 774. He is our talkback lawyer today. Max in Bittern. Hello. Good morning.
Hi, good morning to both of you. Just a question regarding a building defect to a unit of mine that was built in 1998,
Yes.
where the outlet to the shower base was built larger than standard. It created a crack, and then, as you can imagine, moisture escaped, and now there's a huge amount of damage that I'm having to repair to my bathroom. The insurer for the unit came and had a look and assessed it and said because it was done larger than standard and it was pre-existing, then they couldn't accept the claim. And so I'm just now wondering...
So what you're saying is that the drain hole was a large drain hole.
Yeah, exactly. And so
And why has that created a problem?
Because there wasn't sufficient support under the shower base, which is one of those polymarble ones, and a small fissure opened up over time, which moisture escaped through.
So it was stress at the time of construction, basically.
Exactly. And then the first I knew about it was this year when it literally cracked and opened up.
Yes.
And that's when I had to start the repairs and have gone through and found where
Where the problem is. Yep.
Exactly. And that's extended beyond that wet area. So in a sense, it wasn't built properly in the first place. I was able to get from council the documents that were still on file with the name of the surveyor who gave the occupancy certificate and the builder and all that sort of thing. I've been in contact with the person who was the builder at the time and received no joy from them. And I'm just wondering now, with that information, do I have any legal options to seek?
Max, all of these things come with an insurance policy that's good for 10 years.
Right.
You've got 20 out of it. You or your predecessor has got 20 out of it.
Yeah.
My difficulty would be proving what your loss was.
Right.
On one level, it's the cost of replacement. On another level, it is, I've got 20 years out of this shower now. How much am I, by law, entitled to expect?
Right.
Now, I know that for lots of people, showers last a lot longer, shower bases last a lot longer, but I have seen them fail.
Yeah.
So my difficulty is actually working out how much out of pocket you are when I look at the fact, think of it as not as a shower base, but as a car that operated really well for 20 years, and at 20 years you find that something that was part of the manufacture wasn't as good as it ought be. What are you out of pocket?
Oh, it's in the vicinity of $10,000.
Ah, yeah, but my view would be you only had a 10-year guarantee and it lasted the guarantee period.
It got to the 10 years. But you still think that's not reasonable, Max?
It's more because it wasn't done properly in the first, so it wasn't done to the standard.
Yeah,
and the cavity,
basically it's the same issue. You're covered. You've got a 10-year builder's warranty, and that's your problem. Not a 20-year builder's warranty.
But what is the obligation on that surveyor who comes in and signs a certificate when they're signing off on something that hasn't
Max,
been done
if you read the certificate of occupancy very carefully, it says this is not a warranty by me that the building meets all of the built requirements of the building code. All I'm telling you is that it's suitable for occupation.
Which it clearly was for 20 years.
Yes.
But who?
I think
No. It's what your suggestion, Max, is this. is that the person who signs off as the building surveyor has looked at each and every element in the construction and is certified that each and every element complies with the building regulations that applied at the time.
Yeah.
If you read a certificate of occupancy, they make it very clear that the building surveyor is not giving that warranty, but is telling you that it is suitable for occupation. So if there was no water, you wouldn't get a certificate of occupancy.
Yep.
Sure. Yeah.
Right.
Max, good luck. And speaking of no water, Andrea in Blairgowrie, hello.
Oh, hi there, Virginia and David. Thanks for taking my call. I regularly stay at a hotel group in Melbourne when I go up, so weekly basis, thereabouts. I stayed recently, unable to have a shower in the morning before departing.
Did they run out of hot water?
Yes.
Uh-huh.
They run out of water entirely or just hot
No,
water?
the boiler, I think he explained, had gone down.
Yep.
So there was a bit of lack of communication between the cleaner, the front desk and myself. I waited in the room because she said someone was coming up.
Yes.
I was going off to a meeting, so in the end I left and I said to them as I was checking out, disappointed, sort of what happened. Oh, I've been up to turn the boiler back on, I think was how he phrased it.
Yes.
And I said, oh, gee, does this happen very often? He said, oh, yeah, sometimes. Anyway, so he said, look, I'll give you $20 off. And I said, oh, I don't know that $20 is really sort of adequate under the circumstances. I'm going off to a meeting and I haven't been able to have a shower. And he said, well, you can go up and have a shower now. And I said, well, it's half an hour after check-out.
I don't have a time, yes.
Yeah, I'm heading to a meeting. What do you think? He said, oh, well, and sort of piped away with a well-rehearsed sounding phrase that he was obviously told. Anyway, so I took it up with the manager of the front desk the next day, and he was very apologetic and said, call me directly next time or contact me directly next time you'd like to come and stay, and I'll give you a special rate. And I said, oh, look, that's really terrific. I stay with this hotel group a lot.
And is that satisfactory for you?
No, I didn't think it was. And I said to him, well, give me an example. Because
Andrea, I'm stuck. My difficulty is actually trying to quantify your loss.
Well,
now,
I couldn't have a hot shower. And
I accept that you couldn't have a hot shower, but you stayed there for the night.
Yes.
And one of the elements in the package that they were providing to you, the plumbing wasn't working as it ought to have been. You're entitled to make a claim for compensation. My question is you've got to be able to establish what your loss is. Now, if you were staying at my hotel and I told you, look, everything's the same except the hot water service is not working, how much less would you expect to pay? Given that I have the only bed in town and my normal rack rate is $100, how much would you be prepared to pay for my room?
$100 is half of what I pay.
No, we're talking about the philosophy here of...
Yep, okay. Look, okay. Well,
I mean, I suppose my question is...
unprepared, fully, if you're going to a meeting and you'd like to prepare properly...
Yes.
And that entails a shower and feeling refreshed...
Yes.
I'd suggest a little bit more than 20, even in your case, if you were charging me 100.
Okay. Well, that's why my hotel's going out of business. It's too cheap, right? Look, Andrea, my view is I'd hang out for a better rate next time you stay there.
Yeah.
But I would have thought you might get $20, you might get $50, but, you're in the room for 10 hours and 10 minutes of it isn't getting what you want.
Look, Andrea,
my difficulty is putting a figure on it, Andrea, and if I did, it wouldn't be a lot of money.
Sure, and for the non-legal response, I'd also file it under stuff happens. I mean, this stuff happens in hotels sometimes.
It does.
It really does. And we would like the world to work like clockwork, but it doesn't. How'd the meeting go? Did you nail it nonetheless?
Look, all was good. Thank you very much.
But think how much better she would have done but for the shower.
David, don't open that up again.
I would have been sparkling. But the other thing is, can I just mention too that it was a $200. I paid $200. Which for something, yes, I booked at the last minute, so I paid more than I would normally for that particular hotel group. But
Same
I thought
issue,
$20,
Andrea.
No, look,
Okay.
I
Right.
get it. I've stayed in $400 hotels sometimes, and for some reason there's a clanking noise right down the hall all damn night.
Or the engine, or the air conditioning.
Or the air conditioning's too noisy, or you can't turn it off, or you can't turn it on. And, them's the breaks. I guess you could go fighting it, but my advice would be get on with your life. Dave in Brunswick, hello.
Oh, hi, David, Virginia. How are you?
Good, thanks.
Question regarding the insurance excess in a building I own a flat in. Went from $250 a year for water damage up to $20,000 a year due to a big flood that happened a couple of years ago, and the insurance company increased the excess. Apparently in AGM, a circular was sent out. I didn't see it. It was brought up in an AGM that I didn't go to.
Yes.
And anyway, a burst pipe happened underneath my unit that caused a whole lot of damage to units downstairs.
Yes.
This was a pipe that I had no access to.
It's not even your pipe. It'll be a pipe in the slab between yours and the unit below, won't it?
Exactly, but because it services my apartment exclusively from the common pipe, the OC are telling me that it's my responsibility and that I'm liable for the $20,000.
How old is your block, Dave?
Beg your pardon?
How old is your block?
Oh, probably about 60 years old, 800 years old. It's a really old building.
Okay.
So they're trying to sting me for the $20,000 excess. And the only way I could have even serviced this pipe would have been to go through the ceiling of the unit downstairs.
Dave, I'm going to take that on hold as a question.
Okay.
I'd like to think about it a little bit. I know that it's an owners corporation pipe. I know of the provisions in the owners corporation legislation that basically says if the pipe's for your benefit, you pay for it. I've just got to think. I would like to think a little bit more, and we're coming up to the news.
We are indeed. David, thank you, and thanks for calling in as well, Dave. Hey, the hot water issue has completely exploded online. In fact, there's a lot of hot air about the hot water issue, David Whiting. You won't be surprised.
No.
It's being described as one of the greatest first world problems that's ever been ventilated on this show. And the suggestion being, take a cold shower for just one morning, perhaps.
Well, that would certainly wake you up, wouldn't it?
Very refreshing, a cold shower. Really
Not in the
focuses
middle of
the mind.
winter.
Other suggestion was you've got a little kettle there in your room, boil some water.
And have a bath.
You've got your little sink, hot water there, cold water there, and the old possum wash, as they say.
Great.
You've got to be flexible, folks, because stuff does happen. David Whiting, your talkback lawyer, he'll be back with you. Well, not next week. He won't be here for Cup Day, but I will be.